So one of the very early things in the book is a kind of disclaimer: don't expect everybody to agree with everything here. That ain't going to happen. There is no one way. I had come out of a long period of my career thinking, well, if this is coming from me, it's bound from Mount Sinai, and that's the way. And aside from that being an arrogant approach, it's also just not true. There is no one way. And the only judge of what is any good is whoever has to go into the trenches and use it. And so we started to see more and more and more about, not just from that project, but in general, what have the neuroscientists learned about how the human brain makes decisions. And it's very different from what the 20th century psychologists thought. In fact, most of that stuff has now been shown to have been not just speculative, but wrong speculative, with all due respect. And it's radically changed some things. And that helped reframe that beginning of the opening, so that it was, if you get that alignment in place, you start winning in the first 2 or 3 pages of your opening. And it gives you a definite foundation to build everything else in the case on. So long after the jurors have forgotten exactly how you started your opening, that's still controlling how they think.
Can you tell us, what is the concept of alignment and how does it work?
What we know, we've thought this for a long time. If you followed Greg Cusimano and David Wenner's early work, they certainly had this concept embedded in their work on bias. And I've known it from my work in theater, where the impressions you give an audience at a certain point control things for the entire rest of the play. And then along come the neurosciences showing that this is not just, more 20th century speculation. This is really what's going on under that skull, or in that skull. What alignment does, and it's very simple how to do it. So explaining why it works is much more complicated. But what it does is it gets the jurors to start believing something important about your case. Doesn't have to be the most important thing. It doesn't even need to be the central thing. Just so they start, because the old advice, primacy means people remember the first thing they say, and that's simply false. What is true is that people tend to continue to believe what they start to believe. The first thing you believe about a new situation, it's a very tiny tendency. But if the next thing they hear reinforces that initial tiny little baby belief, that baby belief gets a little bit bigger. And so now the phenomenon happens stronger with the third thing. So that by the time you're far enough into your opening, as this all gets done and open, the alignment is maybe anywhere from 3 to 5 minutes long, depending on the case. In some cases, it's 2 minutes. But by the time you, for example, if you start with alignment and you get this little belief that, yes, the taxi company really didn't put the right tires on their cars, they should have replaced the tires earlier, and they believe that now. That's taken because you show them on such and such a day, this happens, this happens, this happens. Each one of them illustrates one of those, if you can get all those in, even if not, even if it's only the event in the case itself. The jurors start to accept that. They have no reason not to, and they do, if you're careful how you do it. And then when you get to damages at the end, you got a jury that's yours. And now the poor defense attorney has got to get up and put on his or her case. And any damage they do, you've got the first witnesses to take care of. It's a lovely little system. The only thing I'm ashamed of is that it took me, 25 years in this business to finally figure out, how do we get jurors so oriented toward our side that every new thing they hear will be that phenomenon that fulfills the bias that says, whatever I hear about something I pretty strongly believe, I will twist grotesquely one way or the other, or make myself believe, or use to reaffirm or strengthen my existing belief.
One thing I have found that really helps, and it doesn't mean that what I'm saying is true, but it's a mindset trick that has helped me retain my demeanor in trial. And that is, I have a mantra. The jurors are taking time out of their lives because they want to do the right thing. And so I'm going to trust them to do the right thing. The judge wants to follow the law and do the right thing. I may or may not agree with it, but the judge thinks he or she is doing the right thing. So I'm going to trust the judge and respect his or her decisions. And then I'm going to have fun while I'm here. So when you have that ruling you don't like, you just tell yourself, well, the judge is doing what she thinks is right. I just got to live with it. And you go on and you just kind of let it flow through you, because the getting mad is not productive. You can do that after the trial, but when you're there, it separates you from the jurors.
And the other thing that is covered in Damages Evolving is what I think is a growing awareness of the importance of empathy, which is a very tricky word. It means to see things through another's eyes and to partly share what they are feeling in their given situation, which lubricates the wheels. So that when somebody does something like that, whether it's a defense attorney or a juror that I don't like in a voir dire, or whatever it is, that I'm not assuming their universe is mine. In fact, I know some judges who are from different universes, but that's a different story. But rather, I'm assuming that there are differences in how they're seeing the world, what is driving them, understanding the pressures a defense attorney has to stay in business that come from those pressures that come from the insurance companies makes it a lot easier for me to deal with that person rather than my just thinking that person is a jackass. I'd write a note to the attorney I was sitting next to, and the paralegal would have written the same note 5 minutes earlier, and the attorney didn't bother to look at that one. But mine, he's paying me for, he looks at it and he doesn't. I've sat in endless meetings where the men will dodder around about a solution to something we're brainstorming, and the woman will say something, and that's when they check their cell phones. They still have that. They still do that today. They check their email. I mean, there's something rich in that other point of view. And to make the argument that the old stupid arguments about women shouldn't do this, that's pure crap. But what I'm saying is not just a matter of equality, but in two different things, there's a great strength. Laminated wood is indeed stronger than a solid piece of wood every time. That's an old engineering principle, but it's true. Yeah, so I think there's something to that. The basic rule is whoever the best person is for the job, they should do it. What you're trying to do here is make an exception to that. But if you think of how can I use them in a way where it's at their skill level, etc., and then give them on their feet in court clothing, preferably in a courtroom, practice doing the damn thing. Bring in, hire some kids to come in and be witnesses, hire some actors from a local college for $50, whatever. So they can actually, because half the reason younger or less experienced attorneys don't do all that well at first is they're scared to death. And a lot of that is, shit, I'm suddenly in a real courtroom. It's like taking a kid from the Little League and putting him on the mound in a World Series game. It really is. If I spend the whole trial in this orientation to you, I never become one with you. They never really get me. They get me at work. When I spend a lot of the time oriented in their direction with them, not just opening and closing. And even in opening and closing, consider it a dialogue. It's not just you giving them a bunch of conclusions. It's you working with them to arrive at a mutual understanding. There's all kinds of things like that you can do to get that jury aligned with you. And it's one of the things that is the equalizer between attorneys who come out with great charisma and brilliance and natural talent and those who don't. The ones who don't will probably be better later in their careers if they have been learning the whole time than just relying on those natural gifts they have. And I see this all the time. The legendary attorney and their less experienced, not even as smart colleague, because some people aren't smart enough to always hire people smarter than them. And it's the colleague who's doing the brilliant work, because the colleague has had to learn how to do the brilliant work. The automatically talented one hasn't progressed one day. You see all over the country lawyers who did really, really well early in their careers They got famous. Everybody knows them. They're in all the right groups and organizations that honor those people. They're not the ones bringing in the verdicts. They're not some of them are, sure, but a lot of them, they're mired because they never had to do that work. What that whole area on lost damages does is open up an area at least as big as the one we've already traditionally been using. In most cases, one example and I'll shut up, every single case that has an impact to a human being, even if it doesn't touch the human being, even if it's like a whiplash or something, make sure there's no brain damage, because there often is. And brain damage can skyrocket your verdict once you know how to do a brain damage case. But brain damage happens much more easily than you think. If somebody falls down, even if they don't hit their head, or even if you don't know that they've hit their head, they cannot hit their head hard enough to cause brain damage. That's falling 5 or 6 feet from head to floor, much less all the other things that happen to us. Thank you, and I love that you do these things, not just with me, but with anybody. These things are such valuable things for the profession, and they didn't exist a decade or two ago. So thank you so much, Michael.